Hi, I'm Tre Flennaugh, and I'm doing my presentation on genericide. Genericide is a term used in trademark law, so before I go into detail on that, I'm going to give some background on trademarks. A trademark is a word, name, symbol, or device used to identify and distinguish goods from those being sold by others and to indicate the source of the goods. For example, the Nike swoosh is trademarked, so you cannot sell anything with the logo on it. If you do, Nike could sue you saying that your product or service is likely to cause confusion on the source of the product. And you could be accused of trademark infringement, meaning you must stop selling the product, destroy all other products with the logo on it, and very possibly pay punitive damages. Names, sounds, and even shapes can be trademarked as well. For example, the shape of Coca-Cola bottle, the name Taylor Swift, and the McDonald's jingle are all trademarked. The basic requirement to be eligible for trademark protection is it must be used in commerce and it must be distinctive. Determining whether a trademark is distinctive is very subjective, which is why we use the 5 levels of distinctiveness. These are generic, descriptive, suggestive, arbitrary, and fanciful. The more distinctive, the more likely it will be registered as a trademark. Generic names are never entitled to a trademark, and fanciful marks will always be viewed as distinctive enough. Generic terms are common names everyone uses for a particular product or service. For example, a store that sells tables cannot trademark the word table. The next level is called descriptive marks. These are terms that merely describe a feature of the product or service. In general, you can only get a trademark if you prove your brand has acquired distinctiveness, meaning most people in the market think of your product when they hear the brand. For example, American Airlines is a descriptive mark, but it gets its name trademarked due to acquired distinctiveness. When people hear American Airlines, they think of the brand rather than any American airline. The third level is suggestive marks, which are seen as a little more distinctive. These marks allude to features of your product or service in a subtle way. An example of this is Netflix. It's not directly describing the company, but alludes to the service subtly. Fourth are arbitrary marks, which are dictionary words that have nothing to do with the product or service. Apple is an arbitrary mark because Apple Incorporated doesn't sell apples, or else it would be a generic mark. Other examples are Domino's Pizza and Camel cigarettes. Last are fanciful marks, which are invented terms that have no meaning other than to identify a product or service. Examples are Pepsi and IKEA. So fanciful, arbitrary, and suggestive marks are considered to be inherently distinct. Descriptive marks need acquired distinctiveness for a trademark, and generic marks are never distinct enough for a trademark. So what is genericide? Genericide is when the public comes to view trademark names as referring to the product themselves, rather than distinguishing the source of the products. This leads to the loss of a trademark and can happen to very distinct brand names that are almost too popular. For example, the word trampoline used to be trademarked with the generic term of a rebound tumbler. The word was used so much to the point that people thought of the product rebound tumbler when they heard the word trampoline rather than think of the brand trampoline. Other examples of this are escalator and aspirin, which both lost their trademarks due to genericide. So this brings me to the court case, which is a recent dispute over genericide. In 2012, Chris Gillespie registered to acquire 763 domain names, including the word Google, such as googledisney.com or googlenewstv.com. Google Incorporated filed a complaint saying the domain isn't allowed under the registrar's term of use because it's similar to Google's trademark and was registered under bad faith. This led to Gillespie and David Elliott to petition for cancellation of the Google trademark, saying it's a generic term universally used to describe the act of internet searching. The parties filed cross motions for summary judgment on the issue of genericness. The district court ruled in favor of Google and Elliott appealed. So the issue is if the primary significance of the word Google to the relevant public is as a name for internet searches generally, and not as a mark identifying the Google search engine in particular. Elliott bears the burden of proving this by a preponderance of evidence. Elliott argues that it is a fact that the majority of the relevant public uses the word Google as a verb, like saying I Googled it, and that this constitutes genericness. One thing Elliott used as evidence was he conducted surveys asking, if you're going to ask a friend to search for something on the internet, what word or phrase would you use to tell them what you want them to do. Over half of the answers included using Google as a verb. He also referred to the media for examples of the same thing. Elliott claims that because of these reasons, Google has become a generic term for searching the internet. Google defends itself by saying verb use doesn't relate directly to generic use. Even though Google is a verb, it's difficult to prove whether people are saying it with the Google search engine in mind or with no particular search engine in mind. For example, one piece of evidence Elliott used was a T-Pain lyric where he says, "Google my name." Although it is used as a verb, there's no evidence that he's saying, use just any search engine to look up my name, or specifically saying to use the Google search engine to look up his name. To further prove this point, Google conducted a survey that resulted in 93% of respondents identifying Google as a brand name rather than a common name for search engines. The appellate court ruled in favor of Google because verb use doesn't constitute generic use. This means they can keep their trademark. Thank you.